Your grandpa is struggling, and the farm is getting too much. You want to help, but who gets the land when he is gone? What if your parents are too old to work and need care, but there is no social security? What if your older brother gets everything, and you get nothing? These were very real, often terrifying questions for people in medieval times, from roughly 1000 to 1500 C. Number 8. Primogeniture and entailment. Imagine a grand estate, rolling fields, and an imposing stone manor house, the heart of a family's wealth and power. This wasn't just a pretty picture, it was the entire foundation of their existence. In medieval Europe, the land was everything. It provided food, status, and protection. How it was passed down truly mattered. And for many centuries, a system called primogeniture ruled the roost. This meant the eldest son, and only the eldest son, inherited all of the real property, the land, and any titles that went with it. If there was no son, sometimes the eldest daughter might inherit, but often the inheritance would go to a male relative, a brother or a cousin, to keep the lineage going through male lines. This tradition was not just a suggestion. It was deeply ingrained in the very structure of society, especially among the nobility and gentry. Consider a powerful baron, Lord Reginald. Nearing the end of his days, he had 3 sons and 2 daughters. Under primogeniture, his vast lands, his castles, his forests, and even the peasants living on them, would pass entirely to his firstborn, Thomas. The younger sons, John and William, would get nothing of the land directly. This did not mean they were left totally destitute. Often, younger sons might be given an allowance, perhaps a small portion of money, or they might be encouraged to join the church or the military paths that offered their own forms of status and opportunity. Sometimes, a younger son might receive a small, non-inheritable property for his lifetime. But this was a gift, not an inherited right. For the daughters, their inheritance usually came in the form of a dowry, a payment given to their future husband's family when they married. This dowry was intended to secure their place in a new household and provide for them. But it was not land in their own right. The system of primogeniture was often combined with something called entailment. This meant that the land was not just passed to the eldest son, but it was also locked into a specific line of descent. The current owner, even Lord Reginald himself, could not simply sell off chunks of the land or give it away to whoever he pleased. The land was entailed to his heirs, meaning it had to stay within the family, specifically within the male line through the eldest son. This ensured the continuity of the family's power and prestige for generations. It was a way to prevent a spendthrift lord from squandering the family's fortune, ensuring that the next generation would inherit a stable, intact estate. Historical records from England, such as the Statute de Donis Conditionalibus from 1285, show how deeply ingrained this concept became, formally restricting the transfer of entailed estates. For the elderly, this system had significant implications. If Lord Reginald, for instance, had only one son, Thomas, and Thomas passed away before him, the question of who would inherit became complicated. If Thomas had a son, that grandson would likely be the next in line, bypassing any surviving younger brothers of Lord Reginald. But what if there was no male heir at all? The land might then pass to a distant male relative, or in some cases, revert to the feudal lord from whom the land was held. This could leave an elderly widow, or even the old lord himself, in a precarious position if the new heir was not kind or obliged to support them. The control of the estate was often passed from father to son, only upon the father's death. This meant that an elderly father, even if infirm, maintained ultimate control over his vast wealth until his last breath. He could not be easily pushed aside or forced into retirement by an eager heir. This gave the elderly patriarch a powerful position within the family, even when their physical strength might be fading. They held the purse strings and the power of disposition, meaning they decided on the final arrangements for the estate. Their decisions were binding under law, provided they were of sound mind when they made them. This allowed an older lord to, for example, arrange a marriage for his youngest daughter or make provisions for his unmarried sisters, knowing that his wishes would be carried out after he was gone. Medieval legal texts from various kingdoms across Europe confirm the authority of the patriarch until his dying day. Primogeniture, while creating stability for aristocratic families over centuries, also created a class of disinherited younger sons and daughters who had to find their own way in the world. For the elderly at the top of the social ladder, it meant security in their control over their property until their death, a significant power that could not be easily challenged by ambitious offspring. It cemented a fixed social order and ensured that great wealth and influence remained concentrated in specific family lines century after century. Number 7. Dower and jointure. While the eldest son usually got the family's main estate, medieval law had ways to protect other family members, especially elderly women. One crucial way was through dower. Dower was the legal right of a widow to a portion of her deceased husband's land or property for her lifetime. This was not a gift from her husband's will. It was a right granted by law itself. The idea was to ensure that a widow, especially one who had contributed to her husband's household and perhaps borne his children, would not be left destitute after his passing. It was a recognition of her continued status and needs. Typically, a widow's dower amounted to 1/3 of all the lands her husband held during their marriage. This meant that even if the main estate passed to the eldest son through primogeniture, a significant portion of the income and use of the land would be set aside for the widow. She would not own the land outright. She would only have a life interest in it. Upon her own death, the dower lands would then revert to her husband's heir, usually her eldest son. This ensured the land ultimately stayed within the family line, while still providing for the elderly widow. Records from feudal courts in England and France show numerous cases where dower rights were upheld, allowing widows to maintain their social standing. Consider Lady Eleanor, whose husband, Sir Geoffrey, passed away after a long marriage. Their eldest son, Robert, inherited the bulk of the estate. However, by law, Lady Eleanor was entitled to the income from 1/3 of Sir Geoffrey's lands. This might mean she received a specific manor house and its surrounding fields, or perhaps the income from a portion of the family's rents. She could live in the house, manage the farming, and collect the rents all for her own upkeep. Robert, while being the new head of the family, could not simply kick his elderly mother out or refuse her this right. Her dower was a legal entitlement that had to be respected. This provision was particularly important for elderly women who might not have other means of support if their adult children were unwilling or unable to provide for them. Over time, another arrangement became popular, especially among wealthier families: jointure. Jointure was an alternative to dower. Instead of receiving 1/3 of the husband's land after his death, a jointure was an estate or property settled upon the wife before or at the time of the marriage. This property was specifically set aside for her use and income if she became a widow. The advantage of jointure was that it provided more certainty for both the husband and the wife. The husband knew exactly which lands would be tied up for his wife's support, rather than 1/3 of his entire estate being calculated after his death. The wife, in turn, knew precisely what she would receive and where it was located, potentially avoiding disputes with her stepsons or other relatives. Legal documents from the 14th and 15th centuries often detailed jointure agreements, showing families carefully planning for the future. For example, when Lady Isabella married Lord Thomas, their marriage contract might have included a jointure. It would state that if Lord Thomas died before her, Lady Isabella would receive the manor of Willow Creek and its attached lands for the rest of her life. This arrangement meant that Isabella had a secure place to live and a guaranteed income in her old age, regardless of how her husband's main estate was inherited. The heirs to Lord Thomas's estate would inherit Willow Creek only after Lady Isabella's death. This provided a clear path for succession, while still ensuring the elderly widow's comfort and dignity. Jointure was often preferred by landholding families because it allowed for more precise estate planning. It prevented the fragmentation of large estates that could sometimes occur with dower, where parcels of land might be temporarily separated from the main holding. It also offered the wife a more stable and predictable source of income, which was crucial for an elderly person who might no longer be able to manage complex finances or agricultural labor. The custom varied across regions, but the core purpose remained: to provide for the elderly widow and ensure she was not left vulnerable after her husband's death. These legal provisions show a clear societal recognition of the need to protect and provide for older women in a time when social safety nets were non-existent. They illustrate how medieval law, even within a patriarchal society, provided specific mechanisms for the welfare of the elderly. Number 6. Deathbed gifts and pious bequests. As life in the Middle Ages was often unpredictable and brutally short, the approach of death brought about a flurry of urgent legal and spiritual arrangements. People nearing their end often engaged in what were known as deathbed gifts, or donatio mortis causa. These were property transfers made by someone who believed they were about to die. The unique thing about these gifts was that they were conditional. If the person recovered and did not die, the gift would be automatically revoked. If they did die, the gift became permanent. This allowed individuals to make last-minute provisions for loved ones or to settle affairs without the formality of a full will, which could take time to draw up and witness. Imagine an elderly merchant, Master Benedict, suddenly struck down by a serious illness. Sensing his end was near, and perhaps having neglected to write a formal will, he might summon his family and a few trusted witnesses. In their presence, he could declare that his prized silver goblet collection should go to his beloved granddaughter Elara upon his death. If Benedict then miraculously recovered, Elara would not get the goblets. If he died a few days later, they would be hers, provided the witnesses could confirm his intentions. This practice, while less formal than a written will, was often upheld in medieval courts, recognizing the urgency and finality of a dying person's wishes. Legal treatises from the period, such as those detailing Roman law influences on medieval practices, discuss the conditions under which these gifts were valid. Beyond immediate personal gifts, many elderly individuals, especially those with wealth, used their final moments to make what were called pious bequests. These were gifts of money, land, or other valuable goods to the church, monasteries, convents, or specific charitable causes. The motivation was often deeply spiritual. People believed that by donating to the church, they could atone for their sins, secure prayers for their soul after death, and ensure a better chance of salvation. These bequests were often substantial, sometimes even diverting significant portions of family wealth away from direct heirs. Consider Lady Agnes, a wealthy widow in her late 70s, who had lived a long and devout life. As she felt her strength failing, she might arrange for a large sum of money or a piece of land to be given to the local monastery, perhaps to fund prayers for her soul, or to ensure that masses were said for her and her deceased husband. She might also request that a certain amount of grain be distributed to the poor of the village each year for 5 years after her death. These were solemn acts, often made in the presence of a priest and witnesses, and they were legally binding. The Church, as a powerful institution with its own courts and legal system, was particularly effective at ensuring these bequests were honored. Ecclesiastical court records from the time reveal numerous disputes over pious bequests, highlighting their importance. These pious bequests could have a profound impact on inheritance. While a family might expect to inherit all of an elderly relative's property, a substantial portion could be diverted to religious institutions. This sometimes led to tension or disputes among surviving family members who felt deprived of their rightful inheritance. However, the spiritual imperative was often so strong that challenges to such bequests were difficult to win, especially if the deceased was known for their piety and the bequests were properly witnessed. For the elderly, making a deathbed gift or a pious bequest offered a sense of control and purpose in their final days. It allowed them to direct their resources to causes they cared about, whether it was providing for a specific loved one or ensuring their spiritual well-being in the afterlife. It was a final act of agency, a way to leave a lasting mark on the world, not just through their descendants but through their contributions to the community and their faith. The medieval period saw the church accumulate vast amounts of wealth through such gifts, which contributed significantly to its power and influence across Europe. These gifts were a testament to the belief systems of the age and the practical realities of inheritance at the point of death. Number 5. Life leases and corrodies. Life in medieval times, especially for the elderly, could be precarious. There was no widespread system of pensions or social security. If you could no longer work, and your family was unable or unwilling to support you, life could become very difficult. To address this, medieval society developed ingenious legal arrangements that allowed elderly individuals to secure their future support in exchange for their property. Two common forms of these agreements were life leases and corrodies. Both involved an elderly person giving up control of their property or a lump sum in exchange for lifelong care, food, and shelter. A life lease involved an elderly person, often a landowner, granting their land or a significant part of it to another person, usually a younger relative, in exchange for a guaranteed living arrangement for the remainder of their life. The transfer of the land was immediate, but the elderly person retained the right to live on it, receive provisions, and sometimes even have control over a specific part of the dwelling. This was essentially a form of pre-inheritance. The younger person would gain access to the land and its productivity now, rather than waiting for the elder's death, but at the cost of providing for the elder's needs. Agricultural records and manor court rolls from across medieval England and continental Europe show countless examples of these arrangements. Imagine an elderly farmer, Master Thomas in his late 60s, whose body was failing after decades of hard labor. He had a strong, ambitious nephew, young Robert, who was eager to take over the farm. Thomas might formally transfer the ownership of his farm to Robert through a life lease agreement. In return, Robert would be legally bound to provide Thomas with a specific amount of grain each year, a certain number of chickens, a steady supply of firewood, and a warm room in the farmhouse for as long as Thomas lived. If Robert failed to uphold his end of the bargain, Thomas could take him to court, and the agreement could be enforced or even reversed. This arrangement secured Thomas's physical needs and allowed him to pass his remaining years in relative comfort, knowing he would not become a burden or be cast out. Corrodies were similar, but often involved non-family members or institutions. A corrodie was a contract where an individual, often an elderly person, would pay a lump sum of money or transfer property to a monastery, convent, hospital, or even a wealthy individual. In exchange, the institution or individual would agree to provide the elderly person with food, lodging, and care for the rest of their lives. These were essentially medieval retirement plans, offering a form of social security for those who could afford them. Monastery cartularies, registers of their properties and rights, are filled with corrodi agreements. For example, an elderly widow, Mistress Marjorie, whose children had moved away or passed on, might sell a small plot of land she owned to a nearby abbey. In return, the abbey would grant her a corrodi. This meant Mistress Marjorie would live within the abbey's precincts, perhaps in a small dwelling, or even eat at the monastic table. She would receive regular meals, access to basic medical care, and the security of a communal living environment. This allowed her to live out her final years in peace and spiritual contemplation, free from the worry of self-sufficiency. The abbey, in turn, gained property and a reputation for charity, along with a stable source of income or resources. These arrangements were legally binding, and the terms were often very specific, detailing the exact provisions to be supplied. Disputes over corrodies and life leases were common in medieval courts, as the elderly sometimes accused their caregivers of failing to uphold their part of the agreement. A monastic chronicle might record instances where an elderly corrodi holder complained of meager rations or cold lodgings, leading to intervention by the abbot or even the bishop. Such disputes highlight the legal weight and importance placed on these contracts for the welfare of the elderly. Life leases and corrodies offered vital pathways for the elderly to navigate their later years, ensuring their survival and dignity when their ability to work diminished. They were sophisticated legal instruments that reflected a societal understanding of the unique challenges faced by an aging population, allowing property to be exchanged for guaranteed care and sustenance, bridging the gap between generations and institutions. Number 4. Wills and testaments. While some property was passed down by fixed rules, like primogeniture, or through specific arrangements like dower, a significant portion of the person's wealth could be directed through a will or testament. This legal document allowed individuals to declare their wishes for the distribution of their movable property, like money, clothes, furniture, jewels, animals, and in many regions also their real property, land. After their death, creating a will was an incredibly important act in medieval society, not just for financial reasons, but also for spiritual ones. A person typically made a will when they felt their death approaching, though some might draft one earlier in life and update it later. The process involved declaring one's intentions in the presence of witnesses. While written wills were common, especially among the literate upper classes, oral wills were also valid, particularly for the less wealthy or those taken by sudden illness. These oral wills would be spoken aloud to witnesses who would then be expected to remember and uphold the deceased's wishes. Church courts, which had significant jurisdiction over wills and personal property, would often hear testimony from these witnesses. Chronicles from medieval towns frequently mention citizens creating their final testaments before their passing. The typical medieval will began with a pious declaration, often commending the testator's soul to God and requesting burial in a specific church or graveyard. Then came the bequests. The most common bequests were to the church, often for prayers, masses, or specific charitable acts, reflecting the deep religious beliefs of the time. After fulfilling religious obligations, the testator would then typically make provisions for their family. This could include leaving money to a younger son, a daughter who had not yet received her dowry, or grandchildren. Servants who had served faithfully might also receive a small sum or an item of clothing. Consider Master Geoffrey, a prosperous merchant in a medieval town. In his will, he might first allocate funds for a specific number of masses to be said for his soul at the local parish church. Then he might leave his finest cloak to his eldest son, Thomas, and a sum of silver coins to his youngest daughter, Anne, to contribute to her dowry. His beloved wife, Marjorie, might be left with the household goods and a specified income from his trade. A loyal apprentice might receive his tools and a small amount of money. The will provided a clear statement of Master Geoffrey's desires, legally binding on his heirs and executors. Court records from medieval cities like London or Paris contain numerous examples of wills being proven and enforced. However, medieval wills had limitation. As mentioned earlier, primogeniture often dictated the inheritance of entailed land, meaning the eldest son would receive the main estate, regardless of the will's contents regarding that specific land. Additionally, laws varied by region. In some places, a widow's dower rights were absolute and could not be overridden by a will. In others, custom might dictate that a certain portion of a person's movable property, often called the dead's part, or thirds, could be freely willed, while other parts might automatically go to the spouse or children. For example, in many parts of England, 1/3 of movable goods might go to the wife, 1/3 to the children, and only 1/3 could be freely willed. For the elderly, creating a will was a crucial act of control, and a way to ensure their wishes were carried out after their death. It allowed them to provide for family members who might otherwise be overlooked, to leave a legacy to the church, or to reward faithful servants. It also served as a moment to reflect on their life and to make peace with their spiritual standing. An elderly parent, though perhaps frail, held significant power through their will. This power could influence the behavior of their children, as prospective heirs would want to remain in their parents' good graces to ensure a favorable outcome in the testament. The very act of preparing a will was a solemn and public declaration, often witnessed by respected members of the community, ensuring that the deceased's final desires were known and enforced. Number 3. Wardship and feudal incidents. Feudal society was built on a complex web of relationships and obligations. A lord granted land of fief to a vassal who in turn owed military service, loyalty, and other dues. When a vassal died, leaving behind an heir who was still a minor, usually under 21 for males and 14 or 16 for females, depending on the region and specific laws, a particular legal situation arose known as wardship. This was a significant feudal incident, one of several rights a lord held over his vassal's lands and heirs. Wardship had profound implications for inheritance, and crucially for any elderly family members left behind. When a vassal died and his heir was a minor, the overlord had the right to wardship. This meant the lord gained control over the deceased's land and, more importantly, over the minor heir themselves. The lord would manage the estate, collecting its revenues, and was responsible for the heir's upbringing and education. This was a highly valuable right for the lord, as they could profit greatly from the estate's income during the wardship period, often far exceeding the cost of the minor's upbringing. Records from the English Exchequer and similar departments in other European kingdoms show detailed accounts of wardship revenues, highlighting their economic importance to feudal lords. Imagine Sir William, a knight, dies suddenly, leaving his young son, 10-year-old Arthur, as his heir. Arthur is too young to perform the knightly duties or manage the estate. His powerful feudal overlord, the Duke, would immediately assert his right of wardship. The Duke would take control of Sir William's castle and lands, managing them through his own agents. Young Arthur would often be brought to the Duke's court, or placed in the household of another noble family to be educated and prepared for his future role. During this time, the Duke would collect all the rents and profits from Sir William's estate. For the elderly family members left behind, such as Sir William's elderly mother or his widowed wife, wardship could be a very difficult time. While the widow might have her dower rights to a portion of the land, the rest of the estate, which often included the primary dwelling, was now under the control of the overlord. The elderly mother, who might have lived in the castle for decades, could find her living arrangements drastically altered or even be forced to move. Her comfort and previous lifestyle might be severely curtailed. If the widow was also old and frail, she might find herself at the mercy of the Duke's appointed agents, who might not be sympathetic to her needs. Charters and feudal surveys from the time often mention the specific details of wardships and the challenges they posed. Beyond wardship, other feudal incidents also impacted inheritance, and the eldest relief was a payment made by an heir to their lord upon inheriting a fief. This was essentially an inheritance tax, a recognition of the lord's ultimate ownership of the land. For an elderly heir or one inheriting a heavily indebted estate, this payment could be a significant burden. Marriage was another incident. The lord had the right to control the marriage of his female wards, and sometimes male wards, to ensure they married someone suitable who would not threaten the lord's interests. This meant an elderly, widowed mother might have no say in her daughter's marriage. If that daughter was a ward, the system of wardship could lead to real hardship. Sometimes a lord might sell the wardship of an heir to the highest bidder. This meant a minor's upbringing and future depended on someone who had simply purchased the right to exploit their estate. The buyer might have little interest in the minor's well-being or the welfare of their elderly relatives. For an elderly matriarch watching her grandson's inheritance and even his future being managed by an outsider, or worse, someone who might abuse the system for personal gain, would have been agonizing. Legal reforms over the medieval period, such as those in England in the 13th and 14th centuries, sometimes attempted to curb the worst abuses of wardship, but the system remained a powerful tool for feudal lords. Until the end of the Middle Ages. Number 2. Disinheritance and exclusion. While medieval law often favored fixed rules of inheritance, particularly for land, there were situations where individuals could be intentionally excluded or disinherited from receiving property. This was not always simple, as legal traditions often leaned towards protecting customary inheritance patterns. However, certain actions, spotises, or circumstances could indeed lead to a person being left out of a will or losing their claim to a deceased person's property. One common reason for disinheritance was illegitimacy. In medieval society, children born outside of a legally recognized marriage were generally considered illegitimate and often had no right to inherit from their father, especially titles or landed estates. Their inheritance rights from their mother were also often limited. This was a crucial distinction, as legitimacy ensured the clear line of succession for property and social standing. If a wealthy lord had several children, but one was known to be born from an affair, that child would likely be excluded from the main inheritance, regardless of any affection the father might have felt. Ecclesiastical law, which heavily influenced marriage and family matters, strongly upheld the concept of legitimate birth for inheritance purposes. Another powerful reason for exclusion was crime, particularly serious offenses like treason or felony. If a person was convicted of a felony, their property could be forfeited to the crown or their feudal lord. This meant their heirs, including their elderly parents or spouse, would be disinherited. For example, if a baron was convicted of treason, his lands and wealth would not pass to his children but would instead be seized by the king. This was a direct and severe form of disinheritance, impacting entire families for the actions of one individual. Records from royal courts across Europe provide numerous examples of such forfeitures, illustrating the profound impact of crime on family inheritance. A person could also be disinherited through a will, especially concerning movable property. While land might be subject to primogeniture, personal items, money, and goods could often be freely willed. A testator might choose to exclude a child who had deeply displeased them, perhaps through disobedience, disrespect, or by joining a religious order without permission. However, completely disinheriting a direct heir from all movable property could be difficult in some regions, where custom or law might require a minimum portion be left to them, known as the legitimate portion or third. Even in those cases, the portion might be minimal compared to what other more favored heirs received. Wills from the period sometimes contained explicit statements of disinheritance, detailing the reasons for the exclusion. Religious affiliation could also play a role, particularly during periods of religious conflict or persecution. In some regions, during the later Middle Ages, individuals who openly practiced a forbidden religion or were condemned as heretics might find their property confiscated and their heirs disinherited. This was a tool used by both secular rulers and the church to enforce religious conformity. While less common for everyday inheritance disputes, it was a potent form of exclusion when it occurred. Chronicles from the Crusades or from periods of anti-heretical fervor show instances of property confiscation for religious reasons. For the elderly, disinheritance could have profound consequences. An elderly parent dependent on their children might find themselves without support if the designated heir was disinherited due to a crime. Similarly, an elderly, illegitimate child, despite a lifetime of work, would likely have no claim to their father's estate, forcing them to rely on charity or their own meager resources. This was a harsh reality, but it underscored the medieval emphasis on legal legitimacy and the consequences of violating societal norms or laws. The concept of an unbroken legitimate lineage was paramount for the transfer of status and wealth. Number 1. The role of the Church and charitable foundations. In medieval Europe, the Church was not just a religious institution, it was a colossal power. A vast landowner and a key player in legal and social life, its role in inheritance and the welfare of the elderly was immense, extending far beyond simply accepting pious bequests. The Church's influence shaped legal practices, provided care, and accumulated vast wealth through various forms of donation and legacy. One of the most significant ways the Church interacted with inheritance was through pious bequests, as mentioned earlier. Dying individuals seeking spiritual salvation often left substantial portions of their wealth, lands, or movable goods to monasteries, cathedrals, and parish churches. These donations were intended to secure prayers for the donors, soul fund masses, or support specific charitable works like feeding the poor or maintaining hospitals. This was a primary source of the Church's ever-growing wealth throughout the Middle Ages. These bequests were legally recognized and enforced by ecclesiastical courts which had jurisdiction over wills and personal property. Charters and monastic cartularies record countless such gifts, ranging from a few coins to entire manors. Beyond simply receiving bequests, the Church also provided direct care for the elderly. Through various institutions, monasteries and convents often operated infirmaries and sometimes even dedicated almshouses. Wealthy individuals, especially those without direct heirs or those seeking a peaceful spiritual retirement, might enter into corrodi agreements with monasteries, exchanging property or a lump sum for lifelong lodging, food, and care within the monastic precincts. This provided a secure, albeit often austere, environment for elderly people to live out their final years. These institutions were essentially the closest thing to retirement homes or hospices available in the medieval period. Records of monasteries often list the elderly individuals receiving corodies in the terms of their support. The Church's legal system also played a crucial role in inheritance. Ecclesiastical courts, distinct from secular, royal, or feudal courts, had jurisdiction over matters related to wills, marriage, and legitimacy. This meant that disputes over wills, claims of disinheritance, or questions of marital validity, which directly impacted legitimate inheritance, were often heard and decided by Church authorities. For example, if a family disputed the validity of an elderly relative's will, alleging they were not of sound mind when it was made, the case might go before an ecclesiastical judge. The Church's involvement often provided a degree of moral authority and a different set of legal principles compared to the secular courts. Canon law. The body of laws developed by the Church contained detailed provisions regarding these matters. Furthermore, the Church often acted as a guardian of last resort or a charitable safety net. If an elderly person was truly destitute without family support or property, they might turn to the local parish church for assistance. While not a guaranteed right, many churches and religious orders engaged in charitable activities, providing food, shelter, and basic medical care to the poor and elderly. This often came from the revenues generated by the Church's own land holdings, which included numerous estates, acquired through generations of pious bequests. The charitable mandates of monastic orders and dioceses are well documented in their historical records. The Church also influenced inheritance through its teachings on Christian charity and family duty. While not legally binding in the same way as a will, the moral authority of the Church encouraged children to care for their elderly parents and urged the wealthy to remember the less fortunate in their wills. This moral framework, combined with the legal mechanisms of bequests and ecclesiastical courts, cemented the Church's pervasive presence in matters of property, family, and aging throughout the medieval period. The vast accumulation of wealth by the church facilitated by these inheritance patterns had profound social, economic, and political consequences for centuries.